Good afternoon, everybody. We're going to go ahead and get started. First and foremost, welcome to everybody for being here, and thank you for participating and joining the first program of 2023 presented by the Connecticut Valley chapter of LERA. On behalf of the Executive Committee, Vice President Gabe Duran, Zach Shern, our Secretary, our Treasurer Joe Dubin, and the rest of the steering committee, welcome to the program. Again, thanks for being here. We think we have a great topic, certainly a great panel of presenters this afternoon. We think you'll enjoy it. We're going to try to leave some time at the end for questions and answers. If you have questions during the presentation, if you could put them in the chat, I will do my best to monitor them, and then we will get to those questions at the end of the presentation. I do have just one quick announcement, if I could. Our chapter does have 2 vacancies on our steering committee. We try our best to maintain a equal representation of both labor, management, and neutrals on the steering committee. So presently, we have a vacancy for labor side, and then we have 1 vacancy for a neutral. So if you're interested, we'd love to have you join us. You can reach out to me directly or anyone else on the steering committee, or shoot me a message in the chat this afternoon if you're interested in joining. So with that, I'm going to just talk a little bit about our program this afternoon and then introduce our panelists, and then we'll be off and running with the program. So as most of you know from seeing the flyer and the emails you got, and then signing up for it, of course, the program is related to college athletics. In a few days, we'll all be watching college athletics on television, most of us anyways. I know I will, big college basketball fan. And if you've read or followed college sports at all, you know that college athletics generates billions of dollars here in the United States. And we all watch the teams play. We all watch the players play, and these players are generating this revenue on behalf of, in many cases, the universities. So our presenters will be talking about that, the state of the law, the evolving state of the law, as it deals with whether or not these college athletes can or should be considered as employees. So our panelists, just briefly, we have Natale DiNatale. He's going to be starting the presentation. He's a partner with Robinson Cole. He works in labor and employment relations. His practice focuses primarily on management side labor relations in the private sector. We have with us also Michael Hsu. He was on he served as a member of the Board of Regents for the University of Minnesota for a number of years. He worked with the Minnesota football players in an effort to avert a boycott of a pretty big bowl game. He was successful in that. Mr. Hsu helped launch the College Football Players Association and is a co-founder of the College Basketball Players Association. Mr. Hsu also has filed the first ever ULP, or unfair labor practice, charge against the NCAA. And he'll be talking about that charge and what's going on with it. And then our third presenter, many of you know well, Michael Hsu. He is the officer in charge at the Hartford office of the National Labor Relations Board. His LinkedIn profile says he's been working at the NLRB for 40 years. He must have started when he was 4. But we're glad to have him here, and he'll be giving us an update on the status of the law at the board. So with that, I will turn it over to Natale to begin the presentation. And again, welcome. And if you have questions, please place them in the chat. I'll do my best to get to them towards the end. Thank you.
Perfect. Thank you very much, Eric. I'm hoping everyone can see my screen. I've got the presentation up, and I'm excited to be here today with Michael Hsu and Michael Hsu on this very interesting question of whether college athletes are employees. There's been so much happening in this area in the past few years, and as you hear from Michael Hsu, and even before that, and it's just an exciting area, and we're thrilled to be able to speak about it today. I just want to note right off the bat, just a little disclaimer that I know I have to do, and there may perhaps be other disclaimers that, this isn't legal advice. Certainly, we're not trying to create an attorney-client relationship. So it's a little disclaimer there before we get started. So what's our agenda on this program of whether college athletes are employees? We want to look at sort of the developing legal landscape. Everyone sort of remembers the decision in 2021, the summer of 2021, in NCAA versus Alston, and that was a unanimous Supreme Court decision that said a lot about the relationship between athletes and universities. And that case arose in the context of an antitrust case, but it's being used now in other arenas. There's also a case out of the Third Circuit Court of Appeals, Johnson versus NCAA, which arises under the Fair Labor Standards Act. We want to talk a little bit about that case and its status. That was actually argued before the Third Circuit last week. There's a discrimination complaint that's been referred to the EEOC that purportedly arises under Title VII. And then we've got Michael Hsu here, who's going to go into some detail with us about developments with the NLRB, including the General Counsel's memo 2108, issued shortly after the Alston decision, as well as potentially some legislative initiatives. And then not necessarily just at the end, but throughout, some perspective from Michael Hsu on the implications of these various developments, the history. Michael Hsu and I had an opportunity to sit with Michael Hsu prior to this presentation, and he's just got a lot to offer, a lot of interesting perspective and history. So we're excited about everything we've got to speak with you about today. So certainly the debate about whether college athletes are employees has been gaining momentum. Just in the arena of the NLRA, we all recall, or many of us recall, the most recent development on that was the Northwestern football players who sought to be represented. They filed a petition. The board ended up punting on that. And then fast forward to 2021, which I think ends up being, if we look back in history, is going to be the year that really things changed. It's also the year that the NIL came forward, but Alston really sets up a lot of what happens to come. And again, as noted earlier, there have been a lot of developments that have been happening in the period before Alston and since Alston that have cited Alston, including the district court's decision in an FLSA case that preceded the Third Circuit arguments that happened last week. The disparate impact issues that have been forwarded to the EEOC, which also cite Alston. Developments in the NLRA and the GC memo, also which cites Alston. And then some other legislation that's been proposed both at the federal and state level. And interestingly, in the concurring opinion in Alston, Justice Kavanaugh cited to the possibility of possible legislation. So, so I think where we want to start is Alston. All right. And again, what was Alston? It was a unanimous Supreme Court case that found that the NCAA rules limiting education-related benefits violate federal antitrust rules. And it was, this arises under the Sherman Act. And one of the things that the universities argued in this case was this idea of amateurism that comes out of a prior Supreme Court decision. And the majority opinion, unanimous opinion, dispelled the notion of amateurism by characterizing that passage from an earlier decision about maintaining a revered tradition of amateurism as college sports as a stray comment, right? Disposed of it as a stray comment. The other thing that's important to note about that decision, the Supreme Court's decision, is what it didn't address. The district court and the Court of Appeals had upheld limitations on athletic scholarships and other compensation related to athletic performance, but the athletes did not appeal those decisions to the Supreme Court of the United States. And the court notes expressly that it doesn't address those issues, leaving open the question of whether those other limitations can go forward. Now, again, this is a case about the Sherman Act. It's a case about the market. Doesn't necessarily mean that these individuals are employees, but there's certainly a lot that happens, particularly with the Justice Kavanaugh's concurring opinion, that sort of leans towards that issue. And Justice Kavanaugh's opinion invites a challenge to the limits that were not appealed on athletic scholarships and other compensations. He expressly states, those remaining compensation rules generally restrict student athletes from receiving compensation or benefits from their colleges or sports. I add this concurring opinion to underscore the NCAA's remaining compensation rules also raise serious questions under the antitrust laws. The NCAA's remaining rules should be subject to ordinary scrutiny. Now, ordinary scrutiny requires a legally valid pro-competitive justification. And he suggested that the NCAA may lack such justification. Now, Justice Kavanaugh was also clear that his comments were even more impactful. He notes that athletes have no meaningful ability to negotiate with the NCAA over the compensation rules. And when we say compensation, we don't necessarily mean pay, right? Salary as we know it. That issue wasn't before the court. But after a lengthy denunciation of the system, which he characterized as generating billions for universities and suppressing income for students, whom he notes are many of whom are African American and from lower income families, he also recognized that there are certain issues. What about non-revenue generating sports? Could athletes in some sports, could student athletes in some sports receive compensation but not others? What does this do to Title IX? Would you have to administer a salary cap? Would this be financially sustainable? But he also then suggests some answers. One, legislation. 2 months prior to that decision, Senators Sanders and Murphy from Connecticut proposed the College Athlete Right to Work Act, which expressly addressed this issue. He didn't cite that legislation particularly, but whoa, there's legislation. That legislation hasn't gone anywhere, but there was an effort at least to put something forward. And then he says something which really got me excited as a labor lawyer, right? Is that colleges and student athletes could engage in collective bargaining. So that really got me thinking, got me excited, and I think got General Counsel Abruzzo excited as well, because it was shortly after this decision that she issued a General Counsel memo which outlines things. So the next thing that I want to sort of touch on is this case that's developing out of the Third Circuit. Shortly after the Alston decision, the district court says that on a motion to dismiss, the plaintiff student athletes who are alleging they are due a minimum wage survived a motion to dismiss. In other words, the mere fact that they're students who participate in sports, that fact in and of itself doesn't mean that the complaint has to be dismissed. Rather, the court said that based on a number of factors, that the case could survive and further discovery could be warranted. And there was an interlocutory appeal to the Third Circuit Court of Appeals, and that argument was heard last week, 9 days ago. I've had the opportunity to listen to it. It's fascinating. Michael Hsu, you've also had the opportunity to I know you shared the recording with me to listen to it. And there are a lot of interesting issues. And you know, there were, of course, 3 judges who heard the case, one of whom said that he doesn't see how these athletes aren't employees. The other 2, we don't know how they're going to move, but it was certainly interesting. Michael, I don't know if you have any comments on that.
Oh, I just think, I mean, it was scheduled to be 30 minutes. It ended up going an hour and a half. It was very interesting. Uh, lots of points of view. The judges, I think, were surprised that, as was I, when I first got into this whole thing, that some of these issues had not been resolved yet. So I think I think we're going to see some action in that case. I don't think they're going to agree with the NCAA that the case this should be dismissed, and I think it's going to be referred back to the district court for fact finding, you know, depositions and discovery and all sorts of stuff. So it should get more interesting.
Yeah, the NCAA argued, and I believe it's the same attorney who argued before the Supreme Court, that the lack of what he called a compensation bargain, right? The lack of the fact that there's any agreement to be paid meant that the case should be dismissed. And the plaintiffs argued that that was similar to the argument raised before the Supreme Court in the Alston decision. And in other words, that they are amateurs, therefore, you know, the case should be dismissed. And the district court on that point disposed of the argument and said that, called the argument circular and unpersuasive. So that was, you know, was an interesting take on that argument, that it was just simply the district court dismissed the argument, and what the NCAA said is that, you know, if without the compensation bargain, you can't get past that. What the plaintiffs argued is the controlling factors have to do with the degree of control that the universities assert over athletes. Now, it was interesting that they didn't limit their claim to scholarship athletes, so-called grant and aid athletes. They also didn't limit their argument to the revenue generating sports. Rather, they said that the minimum wage should apply to all athletes who are subject to this control. Now, this case was brought into Division I, not Division II. There was some suggestion that similar issues arise under Division II. But it raises a question about where that line can be drawn. You know, and so, you know, some of the aspects of control that were raised that during that argument were sort of this, the idea that athletes as part of Division I lose some freedom of speech because they can't disparage other schools. Their classes, certain classes may not be available to them. Certain electives may not be able to be available to them. Certain majors may not be available to them. That was sort of, you know, some of the control that they asserted that the universities could relinquish in order for these individuals not to be employees. And the other one was gambling. There are restrictions on the gambling. For some reason, that was discussed quite a bit. There was also this argument, which is interesting, that there is a field operations handbook that the Department of Labor uses, which suggests that activities you know, for in interscholastic athletics conducted primarily for the benefit of the participants are part of the educational opportunities and do not result in an employer-employee relationship. And the universities relied heavily on that. Now, the district court disposed of that by suggesting that in these situations, it wasn't for the primary benefit of the participants, citing, among other things, the revenue generated by the schools. And, you know, so now there's some question about, well, the FLSA has existed forever, right? Why haven't they been employees forever? Have circumstances changed? And should revenue generating sports be viewed differently than non-revenue generating sports? So, and along the same lines of scholarship athletes versus non-scholarship athletes in Division I. I don't know, Michael, I don't know if there's anything else you wanted to add on the Johnson case before we sort of move forward on that one, but there was certainly an interesting hour and a half of argument.
Yeah, the only other thing I would add that just popped into my head was there was a lot of time spent on the GLAD test. And if you're interested in that, it might be worth a listen.
Yeah, and that was sort of the internship analysis, and whether and how that applied to athletes. Another interesting development in this area is a complaint originally filed with the Department of Education that was referred to the EEOC, and it was a complaint filed by the National College Players Association against Division I schools, that the current system of depriving these individuals of essentially depriving these individuals of compensation has a disparate impact on Black athletes. And essentially they're arguing that it's the cap limiting compensation to scholarships deprives those athletes, most of whom or many of whom are Black or disproportionately Black, of income, which is then redistributed to students in other sports which are non-revenue generating. And what they say in that complaint is that in the pro athlete model, there is generally a revenue sharing model, 50-50. And I don't know what to the extent that is actually the case, but that if in college sports, the revenue generating sports are get far less than that, noting that FBS football players get about 8.1% of the revenue they generate. Basketball players, men's basketball, only about 8.9%, and women's basketball players about 29.9%, and even baseball players only 31.4%. So again, I don't know whether this is going to proceed. I don't know the status of this issue, but it's certainly an interesting complaint, and it cites very explicitly in a huge block of text Justice Kavanaugh's concurring opinion, citing the fact that, and I'll quote it, it's very quick. The bottom line is that the NCAA and its member colleges are suppressing the pay of student athletes who collectively generate billions of dollars in revenues for colleges every year. Those enormous sums of money flow seemingly to everyone except student athletes. College presidents, athletic directors, coaches, conference commissioners, and NCAA executives take in 6- and 7-figure salaries. Colleges build lavish new facilities, but the student athletes who generate the revenues, many of whom are African American and from lower income backgrounds, end up with little or nothing. And that's quoted from Justice Kavanaugh in this EEOC complaint. So have there been legislative initiatives? Yes, and in the Third Circuit argument, there's quite a bit of discussion about whether this should be resolved by legislators, and the NCAA is certainly pushing for that. There have been proposals, as I've mentioned earlier, to amend the National Labor Relations Act. But what the plaintiffs in that case said, look, if the colleges want an exemption, they should go get one from the legislators. It's the exemption they should seek. The law is that they're employees. So there are varying views on this, with the NCAA arguing that the law has existed for decades and no one's ever been considered an employee. Now, Michael Hsu, you're very familiar with the legislative initiatives and how NIL got started, and are we on a similar path here?
Well, we wouldn't have NILs if the legislators and Nancy Skinner specifically in California had not moved into a kind of NIL world, moved the state into the NIL world, and which was copied by many other states, which eventually caused the NCAA to throw up their hands and say, okay, well, you can go ahead and have NILs. But I think the real strategy there was to allow chaos and havoc to ensue, and then therefore bring the Congress together to create, some type of NIL quote unquote guardrails. But I think in terms of the College Athlete Protection Act, which is the current movement in terms of lobbying efforts in California, it started, I think, 2 years ago. Last year, it got through all the committees, but except for the last committee, and they're trying to do it again. And all that would do is provide revenue sharing for 3 sports: football, and men's and women's basketball. And it would be kind of like funds held in trust until a student graduated or left the school. I mean, there's a whole bunch of provisions in there that keep changing because they're just trying to get support in order to pass it. But I think the interesting thing to look at there is they're just trying to create something at the state level that will then create something that will happen in other states and then possibly at the national level.
Does it declare employee status?
It does not affect. In fact, it's done by the same group that is we're going to talk about later, that is pushing the misclassification, et cetera, at USC. But this legislation firmly says that athletes will not be employees.
Interesting. Now, NIL, I didn't distinguish NIL earlier. I mean, and this was a question that even came up before the Third Circuit Court of Appeals. NIL money doesn't come from the universities, right? That's separate money from sponsors. It could be an athletic shoe company or that sort of thing, correct?
Yes, that's correct. And let me just go back and add one little bit of history that I think people find amusing because not too many people know it. But Nancy Skinner, as I mentioned, was the key author of SB 206 in California. And basically, NIL actually was a compromise because what she really wanted was employee status for athletes, but she got so much pushback from the schools in California that she decided to go with NIL because the NIL money would come from third parties, not from the schools. And so it effectively was a compromise where she was able to say, okay, well, if you don't like that, if you don't like employee status, then I'm going to go with NIL. And it has kind of set the whole industry, if you will, in a direction that is probably going to end up with employee status in the end. But she was unable to start with that because of the political winds at the time.
Are we seeing anything like this in other states on sort of like the College Athlete Protection Act coming out of California?
Well, yes and no. Actually, at last year in Iowa, there was an employee status bill that was proposed early in the session in Iowa, and it didn't get any traction. Iowa being a Republican state in terms of its elected officials, its governor, et cetera, has not really wanted to move in that direction. But it was proposed. An employee status bill at the state level was proposed in Iowa last year. So you're going to see more and more of this kind of stuff, I think, as we move along. But a lot of states are not really that interested at the moment in revenue sharing. But I think what California does is really what everyone's got their eye on.
Great, thank you. So in the other arena that we're all very interested in is the NLRB, where I think a lot of this debate started, the more recent debate started with Northwestern, and we've got Michael Hsu here, who's going to help us understand these developments.
Sure. Well, I guess the first place to start is, as is noted here, is the Northwestern University decision in 2015. And in that case, the present Deputy General Counsel, Peter Orr, was the Regional Director in Region 13, Chicago, and he authored a decision finding that a representation case that had been brought to his office by football players at Northwestern University should go forward. And it ended up getting to the board, and the board decided, appropriately, I guess, only in a football case, to punt, as Natale has mentioned earlier. And basically, they said that we conclude that asserting jurisdiction in this case would not serve to promote stability in labor relations. And the basis for that decision was, as the board said at the time, our decision is primarily premised on a finding that because of the nature of sports leagues, namely the control exercised by leagues over the individual teams, and the compensation and structure of FBS football, in which the overwhelming majority of competitors are public colleges and universities over which the board cannot assert jurisdiction, it would not promote stability in labor relations to assert jurisdiction. We emphasize that this case involves novel and unique circumstances. The board has never before been asked to assert jurisdiction in a case involving college football players or college athletes of any kind. There has never been a petition for representation before the board in a unit of a single college team, or for that matter, group of teams. And scholarship players do not fit into any analytical framework that the board has used in prior cases. Scholarship players bear little resemblance to graduate student assistants. Now, the reason they said that, and as Natale put in the next bullet point, is Columbia University, where the board found that student assistants, graduate and undergraduates, are considered employees under the National Labor Relations Act, and stated specifically that an individual may be both a student and an employee, and a university may be both a student's educator and employer. Now, in the wake of that, in January of 2017, then General Counsel Richard Griffin issued a GC memorandum in 17-01. That memo involved a number of issues, including religious, whether or not the board has a jurisdiction over religious-based universities. It mentioned Columbia University and Northwest University. And moving to the topic at hand, though, one of the distinctions that then General Counsel Griffin mentioned is that the Northwest University case was confined to a representation case. And he believed that although the board decided not to exercise jurisdiction over the student athletes in that case, the board went to some pains to emphasize that they were not reaching the issue of whether or not these people, these athletes, could be considered employees under the act. Rather, they were just using their discretion not to exercise jurisdiction because they thought it would be disruptive to the status of labor relations. So then he outlined why he thought that these people are essentially employees under the act, and therefore were they to bring an unfair labor practice charge, it would be something that his office would take jurisdiction over.
Michael, I had a question there. So was it the position that even though the board would refuse to process a petition, that they could nevertheless file an unfair labor practice, that jurisdiction would exist for the purposes of a unfair labor practice charge?
That's correct. That's what I'm trying to say in not as direct terms as you just did, Natale, but so very good. But that was essentially it. Now, as some of you are well aware, following that, there was a different general counsel and a different board with the Trump administration, and General Counsel Peter Robb in 2018 rescinded GC memo 1701. And this was not something that there was a great deal of discussion about. He simply issued a memo rescinding prior general counsel memos that he disagreed with and he didn't think were appropriate. And then there was another election, as we all know. And so then we have general counsel, present general counsel, Jennifer Abruzzo, who was, by the way, Richard Griffin's deputy general counsel when he had that office and issued 1701. And this case, GC memo, is 21-08, and this is the current one. And it finds that she says that she's going to exercise her prosecutor discretion that certain players at academic institutions are employees under the Act. And she says further that she will allege that misclassifying such employees as mere quote-unquote student athletes and leading them to believe that they do not have statutory protections is a violation of Section 8A1 of the Act. She goes to some pains to say she doesn't like the term student athletes. She prefers to refer them as players at academic institutions. I use those terms interchangeably, so please bear with me on that. And one of the things that sometimes gets lost, I think, a little bit in the shuffle here is that the definition of employee under the National Labor Relations Act, which is very broad, and that this is Section 2, subsection 3 of the Act, where it says, quote, the term quote unquote employee shall include any employee and shall not be limited to the employees of a particular employer unless the Act explicitly states otherwise, and shall include any individual whose work has ceased as and so if you've been on strike or that sort of stuff, you're still considered an employee, etc. And then it does by exclusion, but shall not include any individual employed as an agricultural laborer or in the domestic service of any family or person at his home, or any individual employed by his parent or spouse, or any individual having the status of an independent contractor, or any individual employed as a supervisor, or any individual employed by an employer subject to the Railway Labor Act. So basically, the statute that says, the National Labor Relations Act provides that you're an employee unless you're in one of those groups that is excluded. So it's really quite broad.
Michael, how would a finding under the FLSA impact the Act's interpretation, if at all? The interpretation of the Act.
That would be up to the board. Whether if they wanted to pay deference to, either a decision by the Department of Labor or by a court interpreting a decision by the Department of Labor, the board could choose to adopt that or not. Okay. And so one of the things that General Counsel Abruzzo notes is the Columbia University case, in which the board affirmed that its position that student assistants in colleges and universities are employees under the Act. And she notes further that, as Columbia University clearly explained, although Northwestern University denied protections of the Act to certain players at academic institutions, it did so, quote, without ruling on their employee status. So again, in terms of that case, that's something that's emphasized over and over again, that Northwestern, while the board chose not to exercise its jurisdiction, they didn't make a determination as to whether or not the student football players were employees or not under the Act. And she also notes that the board has in the past applied common law agency rules governing employer-employee relationships when applying the expansive language of Section 2(3) of the Act, and notes that under common law, quote, an employee includes a person who performs services for another and is subject to the control or right of control. And She then quotes from GC 1701, the prior memo by Richard Griffin, notes that athletes play football, quote unquote, perform a service for the university and the NCAA, thereby generating tens of millions of dollars in profit and providing an immeasurable positive impact on the university's reputation, which in turn boosts student applications and alumni financial donations. And she also notes that it appears that the NCAA controls the players' terms and conditions of employment, including maximum number of practice and competition hours, scholarship eligibility, limits on compensation, minimum grade point average, restrictions on gifts, etc.
No.
So where that's going is that she then says that she concludes that those football players and other similarly situated players at academic institutions should be protected by Section 7 when they act concertedly to speak out about their terms and conditions of employment or to self-organize, regardless of whether the board ultimately certifies a bargaining unit. So again, she's drawing a distinction between Northwest University being a representation case and the question of, is it an unfair labor practice to deny or to do whatever to student athletes because they are employees and in her view enjoy the protection of the act. And further, she says that leading student athletes to believe that they are not entitled to the act's protection has a chilling effect on Section 7 activity, and therefore where an employer misclassifies players at academic institutions as employees, they violate Section 8A1 of the Act. And in connection with that, she also in this notes Justice Kavanaugh's concurring opinion in Alston and the recent NIL rules. One thing as an aside, I just want to note, if any of you have not read the Alston decision, you can just, I guess, Google it. You can get the full text of it, and I encourage you to read it. It's interesting for anyone who follows Supreme Court cases in general. You know, it's well known that we have strong, often opposing opinions on the current Supreme Court, but here we had a unanimous decision. And Justice Gorsuch wrote the decision. And if nothing else, it's interesting to learn about some of the history of student athletes and how they've been compensated over the years, going right back to, I believe, the 1920s, when some of our most prestigious universities were hiring quote unquote ringers to play on their football teams to try to buttress the reputation of the universities. So it makes for an interesting read. And then, of course, Justice Kavanaugh's concurring opinion is, as Natale points out, most interesting, where he makes an express reference to maybe, you know, collective bargaining is a solution to this conundrum.
Thank you, Michael. And Michael Hsu, you were paying attention when the general counsel issued this memo on the misclassification. I know that you read that and took action.
Yeah, I had been in this kind of space for quite a while. I was actually on the board at the University of Minnesota when the Northwestern stuff was happening, and when the board ultimately punted on that, we received you know, general counsel memorandums from our general counsel on this particular topic. I had been following it, and then it kind of disappeared after the change in administrations. I mean, keep in mind, the Northwestern thing happened under the Obama administration. Okay, and then the Trump administration took over, and then it wasn't until you know, Biden was elected and Abruzzo was, I think she was, she made it through the confirmation process in July. And then in September, she really, at the end of September, she released this memorandum, 2108. And I took action right away. I thought, hey, I got to find some athletes who want to challenge, because we all know that the the term student athletes is a misclassification. It was designed to chill the athletes into thinking they had no rights. In fact, it was a term that was coined by Walter Byers, who was the first executive director of the NCAA in the 1950s, to try and get past some lawsuits where people were injured or even died from playing football. And they created this term, student athlete, to try and make sure that they weren't going to be found responsible for these players as employees. And also the colleges didn't want to pay workman's comp and be held liable. And there were several cases in the 1950s and even in the 70s, I think, up until the 70s. And I think, so I thought, hey, I need to find some athletes who will do this. And I couldn't find one athlete of any sport who really wanted to be the public face behind something like this. So one day I was just talking to some attorneys who were actually at Michigan State and who had been, I think, the first in the recent era. I mean, they were writing memos and papers in 2005, 2006, talking about athletes as employees. And they actually put me in touch with the lawyer who won the Northwestern case in the Chicago region. And after talking to him, I found out that I didn't need an athlete. I didn't need to have standing, or the person that filed the charge didn't need to have standing. And I guess I didn't pick up on that in my one semester of business law class at the University of Chicago. So I really, that was a shock to me. And my first question to him was, okay, then why hasn't anyone done this yet? And he said, that's a great question. I don't know. I mean, this is a 70-year misclassification that I was charging. So basically, I just decided, okay, well, in that case, I'm going to file this. I'll file it against the NCAA. I will narrow it down if and when the NLRB asks me to. And as it turns out they didn't get back to me for basically a year, and told me then that they were going to go with the charge from California that we talked about briefly earlier. It's a narrower case. It only involves football and men's and women's basketball in Division I. And it was one private school, although they did include the Pac-12 and the NCAA. It will be interesting because if they don't resolve it pretty quickly, the school USC will be in the Big Ten. So, well, I have to add another conference to it. But anyway, that's the basic story behind my involvement in this, and I've been very interested to kind of see how this gets resolved in terms of employee status, because I think it's very, very crucial. Having lived through the pandemic, as we all have, we now know the term essential workers. And it became clear during the pandemic that football players and basketball players are essential workers, in that schools were looking at huge losses if they didn't pay, or if they didn't play, the media companies weren't going to pay them what they usually pay. And at the University of Minnesota, we were told that if we didn't play football, it would cost us, or sports in general, it would cost us about $70 million that year. So it's a huge problem, and with all the other reasons that you mentioned, every year there's a March Madness. That's $1.1 billion for the NCAA, and there are only about 1,000 players who play, so it's about $1 million a player, a little more than $1 million a player for March Madness. So anyway, it's an important issue, and I hope to get resolution in a few years, or at least within my lifetime.
Thank you, Michael. Michael Cass, can you tell us anything about this USC charge that was filed about 1 year ago? I've read press reports, but I don't know what you can tell us.
Well, I can't really expand upon that too much. In the charge itself, it alleges that the employers, and again, as Michael mentioned, University of Southern California, Pac-12 Conference, and the National Collegiate and NCAA are all alleged as employers. And it's the first allegation is that they've misclassified employees as, quote, student employee, student athlete, non-employees to circumvent the act. The press reports indicate that complaint has been authorized on that allegation. That was some time ago, back in December, those press reports came out. I'll note, though, that there is another allegation in the charge, and that is that the employers interfered and restrained, an 881 violation, basically, by maintaining unlawful rules and policies in its handbook, including restricting communications with third parties in the media, on social media, related to discipline, etc. So I don't know and can't comment on what the status of that investigation is because it remains under investigation. But, you know, it stands to reason that maybe that second allegation is still being investigated. I don't know if there are other issues that have popped up and under consideration, but I can confirm that a complaint has not yet issued.
But one was authorized. Is that
one was apparently authorized?
Very good. Thank you. So, you know, we've got about 8 minutes left, and we've sort of wanted to reserve some time for questions, and I think there are a lot of questions, and for example, there are questions about Title IX. There are questions about whether this will see a legislative solution. There are questions about what impact employee status would have on college sports. And what about, would it cause universities to drop sports? What impact would it have on a lot of these students who participate in non-revenue generating sports? Perhaps, what impact would it have on their opportunity to participate in sports? How far does this go? Does this go to Division 1, Division 2, or Division 3 impacted? Why not? I think there are a lot of questions about where this line has to be drawn. One of the things that I saw out of the Third Circuit argument was neither side wanted to make this dependent on whether it was revenue generating, but two of the judges, at least two of the judges, asked that question. Does it depend on scholarship? Does it depend on revenue generation? And I don't know, what impact could that have? Michael, what criticisms have you seen to your efforts to get employee status for these athletes? I don't want to create I don't want to violate the law by saying student athlete. Michael's right here in the room.
Well, thank you. Thank you for that. I think that, first of all, you have to go to the culture of higher ed. This is a higher ed business, and higher ed loves this business because of the fan engagement, the engagement of alumni, the ability to bring in students. A lot of students report that they want to go to schools where there's a lot of school spirit around athletics. And so they want to keep on doing it. The competitiveness means that they have to keep on pouring more and more money into it, whether or not it's building new facilities, hiring expensive coaches. There are weight or strength coaches making $1 million now. And obviously you have $10 million coaches in football and in basketball. So, I mean, it's gotten way out of control. As I mentioned, there's the media contract for the NCAA is $1 billion plus a year through 2032. And so there are a lot of people. There isn't one president or one group of trustees who feels comfortable trying to solve these problems, because they are one of maybe 1,200 institutions that belong to and are members of the NCAA. And keep in mind, the NCAA is the trade association that represents all of these schools. And I think everybody is just afraid. They're waiting for someone else to make the move in terms of, is it going to come from Congress? Is it going to come from a court? the Supreme Court ultimately is where everyone's looking, especially after the Kavanaugh concurring opinion and, you know, the 9-0 Alston decision. Kavanaugh, I believe, ends his concurring opinion with the NCAA is not above the law. And a lot of people have taken notice since he said that. And, you know, collective bargaining is obviously something that he teed up, that, you know, the NLRA is, you know, that's what gives at least employees of private institutions the ability to collectively bargain. So I look at that as probably the thing that is going to cause the most problems, because you have public and private schools, and the NLRA is really private institutions. Although, as Abruzzo says in her memo, the conferences and the NCAA are all private organizations, private institutions, although they might have some members who are public entities. So everybody's looking at this, and what you're seeing is a parade of horribles. As I said, the culture of higher ed is to not adopt change or adapt to change very well. Everybody just wants to do the same thing year after year, except they like to get paid more, so they increase salaries all the time, and therefore tuition. And so right now, it just everything is out of whack in terms of, you know, just a general, a student at an institution is paying typically a lot of money to go there. And apparently well, as we know in this country, there are studies that show that it's still valuable to go to college, okay? So there are students who want to go to college and they want to have fun while they're there. While they're spending all this money, they want to be able to cheer for their schools and all that kind of stuff. So most students will not say that they think their peer students who are athletes should not be paid. And so I think that will be very interesting. And then the impact of Title IX obviously is one of the things where everybody's worried, because they believe that if you have to pay athletes, then you won't have as much money to go around, and therefore you might be cutting sports. And everybody's worried about women's sports, but obviously, you know, if you study Title IX, you'll know that the men's non-revenue sports are the ones that have the most to worry about, and they've already started cutting those. So who knows how this thing is going to end up? I think it's very interesting, and I think we're kind of in the final throes where the NCAA has got to figure out what they're going to do if they want to be a surviving entity at the end of this. And I think Congress has shown that they're really loath to take up the cause, and they've got so many other problems to deal with. You know, fixing college athletics just does not seem to be of high priority right now.
Now, interesting, we got a question from someone, and the question is, would Connecticut State Employee Relations Act allow athletes at state institutions to organize as the law currently stands? I don't know of any of us here could answer that question. But have we seen initiatives like happened with Northwestern at any state schools? I'm not aware of any.
Well, like I said earlier in our conversation, the handling of the Northwestern situation and Northwestern was really a unionization, and they did get to have a vote. They never counted the ballots because the board kind of punted at the time when I guess they needed the board's approval to count the ballots, and they didn't get it. But I think that has had the most chilling effect on this whole thing. So whether or not an athlete at Northwestern decides to challenge this again, I mean, we haven't seen it. Not the football team, not the men's basketball team, not the women's basketball team, not anybody at Northwestern has decided to challenge this. And it also has extended to every other school in the country. Nobody has wanted to challenge this yet. But that is the chilling effect of the term student athlete. Students are trained from an early age that they don't have any rights. And when they go to college, it's really drilled into them that they have to follow all these rules, but they really don't have any way of working collectively to improve their terms and conditions. And I think that's something that the NLRB is in position to fix, and hopefully it'll happen. And, as with NIL, once one school decides to go this way, and keep in mind, we've talked about it briefly, there is the possibility that any school could voluntarily recognize athletes as employees, and that hasn't happened. So I think what we're going to see in the future is everyone's waiting for either a new law or a court decision, or a new court decision, and probably we'll have to wait until the Supreme Court ultimately hears the case and decides. But I think we're in good position. We have a Supreme Court that is very likely to look at this and hopefully come out with a positive decision for athletes.
All right.
I have a question, if I might, Natale,
Sure.
maybe for Mr. Hsu. You said earlier that you were looking for a player or players who might be interested in filing the charge that you ultimately filed, and you had a hard time finding a player or group of players willing to do so. What do you attribute that reluctance to?
Oh, it's clear. They are just all afraid to tackle it. They think it's going to affect them with their relationship with their coach, with their school. I mean, if you want to hear the story, I mean, I started out with a D3 football player locally here in Minneapolis, St. Paul, who saw what I was doing. He's a friend of a friend's kid and wanted to pursue this. And it turns out he got cold feet and decided that he didn't want to affect his long-term relationship with his university, even though he was set to play his last game 2 days or 3 days from when I met with him. So even though he was going to be done playing football, he didn't want to jeopardize his relationship with his university. And I think I've heard that from a number of different athletes, from all different sports. And it is one of these things where Northwestern was kind of a one in a million, if you will. The quarterback's name was Kane Coulter, and he, as the story goes, I don't know him, and I haven't been able to contact him. He kind of has left this whole concept, and I don't know what he's doing now. But he basically took a labor relations class at Northwestern, and they went and visited some steel mills like in Gary, Indiana, and he decided that he was a worker, and he decided that they needed to unionize to improve their terms and conditions. And keep in mind, he was at a school where his scholarship was worth, $75,000 a year. And he still believed that he should have the ability to work with his teammates to improve their terms and conditions. But another Kane Coulter has not appeared on the scene since 2014, 2015.
Yeah, and it's odd, and when we watch these teams play and we watch the players perform on the field and on television, and you hear these discussions that are happening about redefining or reclassifying these players, not as student athletes, but closer to employees. But I guess the one thing, at least I haven't seen, and I think you've just confirmed, is that you don't see it coming from the players, at least not yet, or at least not that we've heard.
Well, a lot of players agree. They just don't want to agree with, kind of the inequities and all that kind of stuff, but they just don't want to be the ones to tackle the issue and be the face of it. That's the real problem right now. And I think once either the Johnson case kind of gets to fruition or the NLRB case, once there's more media attention, there's going to be people coming out and saying that they want to be part of this. That's what I'm waiting for.
There's one question in the chat from says it.
Yeah, I see the question about the Ivies giving
the Ivies,
athletic scholarships, which I don't know, and would that change things for them? That's a question that the Third Circuit Court of Appeals is struggling with in the in the Johnson decision currently, and about whether the economic realities test has to be different in revenue generating sports, and does it depend on whether someone is getting a grant and aid scholarship. There are some of the rules around the scholarships for some of the schools, and I don't know them very well, are that the coaches can decline to renew them. Right, so that sort of the suggestion is that the employees are, quote, fired. I don't know if that's the case in the Ivy League schools, but according to the plaintiffs in that case, that doesn't matter. What they say is that if you're subject to the NCAA rules, you know, in that you have these restrictions on speech, restrictions on class schedules, restrictions, you know, on majors, those kinds of rules, then you become an employee. The court seemed to be trying to find some balance there. I obviously don't know where they're going to come out, and I don't know how that would impact the analysis under the NLRA.
Well, I would say, okay, so the Ivies do not give athletic scholarships. But if you read the Abruzzo memo, the 2108 memo, it basically says that scholarships are, you know, while they can be considered an in-kind compensation, compensation is not necessary in her view to find employee status. So I think the Ivies actually, you know, I've talked to some students at Ivy schools and they seem a little bit interested, but they're not really that interested because sports isn't really that big at the Ivies right now. And they do have athletes. They do have people who are recruited to be athletes. In fact, you know, not the NCAA, the Supreme Court is hearing a decision, or is hearing a case between Harvard and the Students for Fair Admissions, and also the I think UNC is the other case, other school involved in the case, and that should be out by at least the fall, maybe the summer, about whether or not they should be able to use the same admission standards that they use. And the Ivies right now, I mean, they do give pluses for athletes. So there is kind of a role to be played there for the Ivy League still. They still care about sports. I mean, it's the University of Chicago that really famously decided that they didn't want to have football anymore, and they dropped out of the Big Ten. I mean, they still have sports, but I think they're Division III. So it's going to be interesting to see where Division III falls out in this whole thing.
Well, on that note, do you see some of the Ivies or maybe other institutions who say, I don't want to pay the minimum wage, I don't want to be subject to these rules, and maybe we should be changing our model and not be subject to the NCAA Division I rules and going to Division III?
Well,
in some places.
Yeah,
anyway.
I mean, and I should have mentioned the Ivies are Division I right now.
Right.
So they could drop down depending on what the decision is. I don't know where the NLRB is going to come out. I mean, one of the reasons I thought a D3 filing would be a charge would be important, because either they would say, oh, we're not interested in D3, there's no way they're employees. Or they could say, yeah, the D3 athletes are employees. And that would have been very interesting to see. And we'll just have to wait a little bit longer to see if, you know, they're going to answer that question.
Well,
Michael, I had a quick question for you, and it goes to the reluctance of students that you talk to, you know, get involved with unfair labor practice charge or a representation case or whatever. I wonder if it's also the prospect of potentially burning bridges. You know, I think depending on the school you go to, if you're successful, I mean, if you're going to Oklahoma or Notre Dame or Ohio State and you're playing football or basketball, you know, the idea that you could get a professional career out of this and become independently wealthy has got to be a big draw. Certainly that's less so if you're playing football at my alma mater, UMass Amherst, who I don't believe has had a pro football player since Greg Landry played for the Detroit Lions, 8,000 years ago. But I wonder, and the other thing is, I wonder if they have any concerns. Well, it's not just the prospect of a pro career that could be jeopardized, but also just, if you're thinking, well, I'm a second string player and it's unlikely I'm going to play pro ball, but I sure would appreciate the coach's recommendation if I go to become a high school coach or a high school athletics director or something like that. And I just wonder if you've heard if that's part of their reluctance.
Yes, definitely that is part of the reluctance. Although the interesting thing is every student knows that or every football player knows that if they make it into the NFL, that they're going to join the NFLPA. So it's kind of funny that that if you're successful, you're going to be in a union, right? And yet a lot of students don't want to kind of take the risk of upending the apple cart, except for the Kane Coulters of the world. And he was able to convince his entire team that they should work together to try and unionize. So, I would say that, in the last year, you've probably been busy with Starbucks and other retailers, and it's the same thing that there have been a lot of unfair labor practices, on behalf of Starbucks and other big companies to try and stop employees from wanting to unionize. And I think those are people who are already employees. Now, athletes have to get employee status before they can get any of the other benefits.
If I could piggyback Mike's question, as far as another, I guess, maybe disincentive for being a player and getting out in front and looking to perhaps change your classification to employee or organize, is the development of the NIL agreements. I mean, we have we have a great women's basketball team here at the University of Connecticut, and we have a player, Paige Beckers. I don't know if you've heard of her, but she's a fantastic player.
She's from Minnesota.
Is she? Okay.
Which is
I read somewhere that her NIL compensation package is close to $1 million this past year, and I wonder if a player has the ability to earn that type of money while in school. They may not be so inclined or as motivated to get out in front like the quarterback at Northwestern.
Yeah, Paige is a great case, and she's actually used a lot of her NIL money to help her teammates out, which was one of the criticisms, was that well, some players are going to make a lot of money and you're going to have locker room issues, and she's kind of turned it around. So I give her credit for that, but she has not, she's not called me to lead a unionization in Connecticut. But then again, UConn is a public school, right? So she's not really in the sweet spot of kind of what I'm working on right now.
Right. Well, if I don't see any other questions in the chat, I don't know if you do, Natale, but we're a little bit over our time. I wanted to thank our presenters, our panelists, and Natale, thank you very much. Mr. Hsu, Mr. Cass. It was a great presentation, very informative on a very timely and developing topic. I know I got a lot out of it, and I'm sure everybody else did as well. Thank you for your time. Thank you to the National LERA for hosting it, putting on the webinar. I appreciate your support very much. Be looking for a program coming in April. We'll send out an email alert on that. And again, if you know people who would like to join our chapter, please spread the word. And if you're interested in joining our steering committee, by all means, please feel free to reach out. And again, thank you, everybody. And
if I could, just one special thanks to Greg Shanklin, who put me in touch with Michael Hsu. I think he's on board, but awesome. Greg was a tremendous help in helping us get Michael. So thank you, Greg.
Yes, thank you. And thank you, Michael, for your expertise and the work that you're doing. Thank you.
Oh, thank you. And I appreciate the opportunity to be with you guys, and anybody with more questions, feel free to contact me.
I want to just add, it's truly been a pleasure to work with the two of you on this. It's
the same here. It's been fantastic.
Thank you.
Wonderful.
Hope we can keep in touch. Take care.
Very
All
good.
right.
Thank you all
Take care.
very much.
Yeah.
Thank
Bye.
you.